What is a motion in limine? How do lawyers use it in lawsuits and in practice? Hi, I'm Guy DiMartino. I am an injury and accident lawyer, and today I'd like to tell you how I use motions in limine in my personal injury practice. A motion is a document that goes before the court and you're asked the court to go ahead and rule a certain way based on whatever motion that you are bringing before the court. Now, a motion in limine is a specific motion that is filed with the court before a trial in a matter, and what you're doing is you're asking the court, saying, "Court, we want you to rule on this piece of evidence and let us know if this piece of evidence will be admissible or will not be admissible." Let me give you a for instance about how I would use a motion in limine in a personal injury case. So I have somebody who's been severely injured in an accident and we are getting ready to go to trial. And what we've learned through the discovery process is that my client in the past has been convicted of a crime. Now, generally, convictions of a crime are admissible if it's a misdemeanor and the misdemeanor goes to somebody's truthfulness. So things like kiting a check, things like shoplifting, fraud, lying. Can you see why that would be admissible? Because that goes to the witness's truth or veracity. Also, felony convictions are admissible. But what if this crime happened so many years in the past where it's so remote? My concern would be that the criminal conviction would go before the jury and the jury would not give my client proper money compensation because they would think that my client was a bad person because my client was in trouble 5, 10, or 15 years ago. So I might go ahead and file a motion in limine with the court and say, "Yes, Judge, these convictions are typically allowed in, but look, this happened to my client when my client was 19 years old. Now my client is 40 years old. How does this robbery, or how does this domestic violence, or how does this felony show a jury what my client is like today?" So this information might be so prejudicial to my client that, "Judge, we want you to rule now whether this information is going to come in." Because if the judge says, "Guy, the information's not coming in," we can present our case one way. If the judge says, "I'm sorry, Mr. DiMartino, this information's coming in, the law says that the defense is allowed to bring it in, I am bringing it in," then we have a choice to make. Are we the first people to bring this to the jury's attention? Do I get up there and voir dire in jury selection? Do I get up there in opening statement and say, "Listen, my client was convicted of this crime on so-and-so date, 15 years ago," those types of things. So that's one way that a motion in limine can be used for me on the plaintiff's side. Defense side usually will file motions in limine regarding insurance, that no insurance coverage can go in before the jury, and other things along those lines. So you can think there are so many situations where we need to go before the court and say, "Judge, is this evidence coming in or is this evidence staying out?" so that we can have an orderly trial in a matter. So that's what a motion in limine is, and those are some of the things that your attorney is going to do before he takes your case to trial that you might not even know about. If you have any questions about an injury and accident claim or a medical malpractice claim, you can always give me a call, shoot me an email, or visit my website and blog. Thank you and have yourself a great day.